Welcome back to another episode of the Anomalous Investor Podcast. Today, I have an expert attorney on trademarking, and she's going to give us all the insight. Her name is Erica Tolbert, and she's going to give us some valuable insight on how to protect our brand, grow equity in our brand, and ultimately just make sure that we're not building equity for other people. That's the way I like to think of trademarks. So, Erica, welcome to the show.
Thank you. Thank you. And that was definitely a great point. A nice way to say it, because a lot of times, it's like, hey, don't build a brand you don't own. But in actuality, better said, don't build equity for someone else because, we'll get into why later on. But well said. Well said. I'll say that.
Thank you. I appreciate you. I wanted to start because normally I just include this in a bio, but I'm really curious myself. There are a multitude of different type of attorneys you could have become. Why did you choose become a trademark attorney?
The funny thing is that, with going to law school, I initially came in with the idea that I wanted to be a corporate attorney. It didn't take long for me to figure out that that was definitely not my path that I wanted to pursue. But it wasn't until my second semester in law school when I took my first property course, and my professor was amazing. But it was definitely one of the hardest courses that you'll take in law school. But I just really fell in love with intellectual property. And definitely coming from the background that I have, with being the daughter of an entrepreneur. My father's a master plumber, and he's had his own business my entire life. I've always had the understanding and an appreciation for the journey of entrepreneurship and building a business from nothing into something that can go on to create, wealth, not only for the existing family, but go on to, provide opportunities for your children, so on and so forth. And so with intellectual property, even though I had this exposure and this, this exposure to entrepreneurship growing up with my father, I only understood the point of hey, as so long as you have your LLC, you're a legitimate business, you do your taxes, hey, you're good, right? And so that was my perspective as to what a business owner needed to have in place in order to be legitimate, in order to be an actual business as opposed to operating as a sole proprietor, right? Which is what most people may do in our communities or, or just starting out, just not knowing any better. So I thought having that level of an understanding was all I needed, and that all that other people needed. And I thought that was common knowledge. But with this property course, learning about the different aspects of brand protection, business protection, all of the different layers, and just specifically focusing on intellectual property, just understanding and just having that introduction into knowing that, hey, when you see a business having that LLC, that has a purpose, right? A purpose that's completely separate from actually protecting the intellectual property component of the business, the branding component of the business. Why is it that you don't see other restaurants naming themselves McDonald's or other supermarkets naming themselves Target or Whole Foods that's not associated with that brand? So starting to think it from that perspective, then I'm like, oh my gosh. There are so many people that, are operating businesses exposed, unaware, completely unaware. And I think that that's definitely why a lot of smaller or scaling businesses are taken advantage of, and things like that. And so it definitely quickly became a passion of mine. And I just knew that, and it kind of just fit, I knew I had to pursue it. And even with starting my own practice, ultimately, I ended up streamlining to only providing intellectual property services because this is definitely where my passion is. And so, long answer short, that's how.
No, I appreciate that because I was curious. That question was for me, so I was definitely curious because you definitely have a lot of options. So I was like, how'd you get here? So
Yeah.
Absolutely. Could you, for those of us that are curious about trademarking, could you walk us through like how does that work, like that process?
Okay, so definitely the first thing to understand with trademarking, the trademarking process, is that it definitely is a time consuming process. That's the very first thing that I think will catch a lot of people off guard. Because typically, if you've ever done anything for your business, in terms of filing anything for your business, more often than not, it's a more streamlined process. It's a quick process. It's something that, you could potentially, figure out on your own with just fumbling through the application, right? Or the form. Specifically like an LLC, for example, you can fill that information out, through your Secretary of State's website in most states at this point. However, with the trademark process, this is a process that is so in depth, and it's going to require at least 12 months after the application is filed. Okay. And so the first thing is to realize that, we're not talking about a local office or a Secretary of State in a particular state. We're dealing with the United States federal government, specifically the United States Patent and Trademark Office. Okay. And a part of the reason why the trademark process is so time consuming as well is because in the past 3 years at this point, so many more people are learning about the importance and the necessity of trademarking their business, and not just the business name. We want to get into the nitty gritty. So like if you have particular products or particular services that have their own, identifiers or labels, all of those things, protecting all of those things and maintaining your protection of all of those things. The USPTO, the United States Patent and Trademark Office, they're overwhelmed at this point. They've got more people trying to protect their businesses than they have people to actually review the applications. And so because of that, the timeline is much longer than what it was in the past. And so that's why we're looking at least 12 months for the entire process. Generally speaking, to make it simplified, from the time that you file your application, it's going to be about 8 to 10 months before the examining attorney with the USPTO actually will review your application. At that point, when they review your application, they're going to be determining whether your application is a strong application. What makes it a strong application is going to be basically knocking down any issues that could prevent your application from moving forward to registration. So they're going to be looking to see, hey, has this name already been trademarked? Or has this logo already been trademarked? Has this slogan already been trademarked? And if it's not the exact thing that's already been trademarked, they're also trying to decide whether anything that's very similar to what you're trying to trademark, has that already been trademarked? And has it already been trademarked for the same goods and or services that you are trying to protect your name in connection with? And so there are a lot of different layers that they're going to be looking at. And that's definitely simplifying some of them. But after that, if you have a strong application and if it moves forward from there, then it goes on to publication in what's called the Official Gazette. And then and that's basically where like the entire world has noticed that the federal government is getting ready to release ownership of this particular name, logo, or slogan to you. And they have 30 days to file a notice of opposition. If they don't oppose your mark, then at that point, that's when you'll officially get the registration. But now if you have complications along the way, that 12 months gets really long, really quick.
Turn into 2 years?
What'd you say?
It can turn into 2 years?
For some people, I've seen marks that have like been tied up in litigation for more than 2 years even. Because if you think about it, let's say, for example, the examining attorney doesn't have an issue with your application, or let's say they do, but you overcome the examining attorney's arguments because either you or your attorney has, drafted up the strongest arguments to prove your point, and you've been persuasive, right? And the examining attorney says, hey, we no longer have an issue. We will allow you to move forward to publication. At that point, if another business who's being very watchful of their intellectual property, much like someone would watch their, real estate property, right? And what that means is basically Most people who have trademarks will subscribe to some type of trademark monitoring or trademark watch services to make sure that there are no brands out there that they would consider to be competitive. That's a little too close for comfort. Okay. And by doing that, you're making sure that someone is always and consistently keeping a close eye out on your brand and on your branding to make sure that there's nobody that falls through the cracks. And so when those businesses are doing that, when those brands are doing that, then you'll know, hey, somebody's getting ready to publish their mark or marks when we're not comfortable with it. It's going to be competition for us. They're going to redirect our customer base, or whatever the case may be. So they file a notice of opposition, and that can land you in litigation for years. Some of those things end in settlement, and some of those things end in you having to cancel your application. Some of those things end in you overcoming those oppositions. But there's just a lot of things that can kind of go hand in hand with that.
Oh, wow. Okay, so I learned something new. I didn't know you can monitor it like that. I thought maybe you just would have like an attorney, or if you've seen something, you had like a grace period or something. I didn't know you could have a service. So I learned something new.
Yeah. Look, there's definitely a lot of wrinkles when it comes down to trademarks. And like I said, that's definitely a very helpful thing, because also one thing is, it's kind of like, are you familiar with squatters?
Yeah. Mm-hmm.
Okay, so we know, like with if there's an abandoned house next door, or down the street or whatever, if somebody stayed there, came and goes they please, the owners of the property were aware but did nothing about it, then they could potentially claim ownership in a capacity to that real estate, right? The same thing works for intellectual property. So if you have a trademark and there are people or businesses, whether they filed applications or they haven't filed an application, but they exist, and you had a reasonable opportunity to know that they existed and you did nothing about it, then you've basically acquiesced or given them permission to exist. Okay. And so when you do that, you're basically saying, hey, you can step on my brand, or you can cross the line however you see fit, and it won't matter to us. Now, worst case scenario, what happens if that brand blows up bigger than you? Or you realize that now your customer base is, being confused between your brand and this other brand, and now it's an issue. But if they've existed for years at this point, now they have an argument to say, basically a squatter's argument to say, like, hey, you had reason to know that we existed. Like, we've had televised commercials. Our social media platform has thousands of followers, so on and so forth. Like, we have a presence, and you've not said anything to us all of these years. And there are a lot of brands that make very compelling arguments to that extent, that will end up leading the person who had the federal registration to have to basically kind of like bow down in a sense. And so it's a real thing.
Oh, wow. Okay. So you can't be like, they'll just come back and say, hey, don't get mad now that we're making money.
Exactly. Basically.
Okay.
Not
Wow.
so small
Okay.
now, huh?
Yeah. Well, when you said that, I thought about, I don't know if you know what Credit One is, but I thought about Credit One and Capital One. Their logos are
Yes.
almost like identical.
Mm-hmm. Even the branding, and I've looked at that a couple of times. I haven't officially looked up to see, whether there's an affiliation or anything like that. But it's definitely on par. They're like really, really similar. And sometimes, and that's even a point that can be confusing for a lot of people sometimes, because sometimes if we see two brands that like have similar, overlapping branding, or like it's very clear that like one is kind of piggybacking on the other, it's very clear, sometimes brands have negotiated coexistence agreements. And so, or settlement agreements, basically, or sometimes licensing agreements. But with coexistence agreements, that's basically where, let's say, for example, you have a brand, but there's another brand that maybe has existed longer than you, right? Your names have some overlap, but it's not entirely the same. You may fall under the same class as the USPTO, has divided up classes, but your services may not be exactly the same, or maybe there is some overlap. Those brands have the ability to sit down and negotiate, basically to say, hey, I promise to stay in my lane. I know you're going to stay in yours. We're not going to intentionally do XYZ. We'll pay you XYZ in some cases, if you will allow us to continue to operate to this extent. And what the other brand will say is, well, yeah, so long as you pay me XYZ annually, or a one-time fee, or a flat fee in some cases, then hey, yeah, we'll allow you to do your thing. Because then at that point, the person who has the registration, the senior registration, they're able to capitalize on their intellectual property. They're able to capitalize on the fact that they have that trademark registration, that ownership. And so that's also a way that a lot of people can monetize trademarking their brand. And in a lot of cases, what people don't realize is, for investors and things of that nature, if you're looking for, whether you're looking for potential partners or investors or just anybody as you continue to scale your business, is that, if you're able to present to them that, hey, this is a brand that, is safe to invest in, the strongest argument is to be able to say, like, hey, I own all of the branding for this business. I own all of the property. So you don't have to worry about, if you purchase this from me, somebody else shutting you down the line. It's kind of like whether you were to purchase property, and you haven't done a title search, for example, and you buy the property and then you're stuck with the big bill. If you're able to tell an investor, hey, if you purchase this, there's not going to be anybody that's going to, be pulling the rug from under you, essentially.
Free and clear.
Exactly.
Yeah. Absolutely. Because one thing that I've seen pop up a lot, and even in my own research, because I know that if you do a little research, Google will tell you, you got first in use and all that kind of stuff like that. What is the difference between your copyright or quote unquote protection you have there versus actually getting the trademark? I know because sometimes people say, okay, I'm going to wait until I make some money or build my brand up, and then I'll come back later and trademark. And then sometimes you could be, shooting yourself in the foot. So do you really have any type of protection there?
So that's a great question. And the thing is that, like, each of them serve a different purpose. And in some ways it can seem overlapping, but it's kind of like if you were to file a lawsuit, in court or whatever, you have to have a certain standing to be able to file certain claims, right? Like, say, for example, if you were in a car accident, then you have grounds to file a lawsuit for, like, personal injury, right? So on and so forth. But only the people that's in the car can file those claims, right, to personal injury.
Right.
Nobody that witnessed the accident will have the standing, right, to say, oh, that hurt my feelings. I suffered emotional distress from witnessing this catastrophic, they don't have standing to do that, right? And so when you come back over to this particular type of territory, with copyright, there are certain claims that could be made if people are infringing on, or others are infringing on, your copyright protections. And there are certain claims that can only be made if individuals are infringing on your trademark protections. Okay. So on and so forth. Each one will serve a different purpose. Each one will give you the standing to be able to, file certain claims and seek certain damages. Okay. Because that's the money, right? So with copyright is with a completely different office. That's with the United States Copyright Office. Copyright is intended to protect content. So when you look at a book, for example, the first thing you see, copyright, blah, 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 blah. Songs have all of these lyrics. It has all this music. copyright. That's content, right? If you're a photographer and you have loads of pictures, or if you're a podcaster and you have loads of podcasts, that's content that you're looking to protect and making sure that the world is on notice, or, anybody is on notice that you are the originator of said content. Copyright is created the moment that you put pen to paper, or you type anything in Microsoft Word, or, whatever medium you choose. Copyright is automatically created. But you can only enforce copyright rights if you have a registration for that copyright. Okay? So that's where copyright infringement comes in. So that's why you still want to make sure that you file that copyright so that you can have the grounds to sue someone for copyright infringement. Okay? Now, and this is kind of where it overlaps. Some things that can be trademarked can also be copyrighted. But for the most part, things that can be copyrighted cannot be trademarked. Okay?
Okay.
Because trademark is specifically, and again, that's what the United States Patent and Trademark Office, trademarks are specifically for things that are considered kind of like, it will identify the source of a product or services, okay? Or product or service. So that's going to let you know if you pick up a pair of shoes, if it came from Nike. That's going to let you know if you pick up a soda can, or depending on where you're from, a drink can, wherever, if its source is Coca-Cola, right? So you have all of these different things. Trademarks are to identify and basically, create a space that allows people, consumers, to know the source of products and services. Okay. So those things are meant for that. And so there are protections that falls for trademarks and protection that falls for copyrights. And ultimately the sad thing about it is, with first in use is really important when it comes down to, like, if you're going to get into the litigation of things, right? So say, for example, you started your company in 2015 and but you never trademarked it because you're like, it's just a small company. I'm not sure if I'm going to take this seriously or not. I'm going to wait until I reach this particular, income, like, until I have this level of profit, X, Y, Z, all the things, right? And you're making this face like, yep, I had those thoughts. But
these are all facts.
Right. But it's really, really common, and honestly, it's fair. It's fair to believe that, like, that's a safe space to, like, really, like, have that as a strong consideration. But in actuality, it can be the worst decision to make. It can be the worst. For a few reasons. A few of the most important reasons would be, if you start that company and, even if, like I said, even if you started in 2015 and somebody comes and you still haven't trademarked it yet, and somebody comes in 2023 and files an application for it, right? Not saying they are aware of your business or not, that part doesn't matter at this point, but they file a trademark for it. And when the USPTO sees their application, hey, there's no conflicting marks in our database. They're only checking their database. So they're going to approve the application. Okay. So their application is going to publication, and granted, again, your business started in 2015. You don't have any trademark monitoring services. You're not keeping an eye out, for those things. You're just operating your business, trying to see, what happens, right? They go through publication, they get their registration. Okay. Now it's a month later and you're like, okay, I'm ready to file my trademark application. Now we've got an issue because we have this person with a registered federal trademark. You had notice, just like the entire world had notice, that they were getting ready to get this trademark, but you didn't file a notice of opposition. Okay. So at this point, things are going to be a lot more expensive for you to try to get that trademark back. And again, emphasis on the try. Okay. Because you're going to have to, send them a cease and desist letter, letting them know that, like, hey, you had common law rights, right? And again, common law rights are, restricted to your geographic reach. But you're going to try to make those arguments. You're going to make your arguments that they're, infringing on any time. You're going to try to reach for anything you can. But what their arguments are going to be, I wasn't aware of your business. I wasn't aware of your business. You're going to have to take me to court to get this. I'm not going to just voluntarily give up my trademark. You're going to come up with all these different defenses, right? And now at this point, you're going to be like, well, man, stuff is about to get real expensive. Do I want to pay thousands and thousands and thousands of dollars? And I'm not exaggerating, because things can get really expensive when you start talking about that level of intellectual property litigation. You're going to have to battle with, do I want to fight for this at this level, which will be exponentially more than it would have cost to either file the application on your own or invest in an attorney preparing the application for you and representing you. Do I want to do that, or do I want to rebrand? So put a whole new face on my business. And so that's why it can be dangerous. And that's also why the federal government has created, like, there are two types of applications. There's an already in use and an intent to use application. The already in use application is for the business that has already launched. You're already marketing your services. You're already offering your services, across state lines. And that's sufficed by, having a website or a social media presence, right?
Right.
Or there's the other application, the intent to use application, which says, hey, I haven't started this business, but I want to make sure that nobody beats me to the punch. So I want to make sure I want to make sure I secure my place in line, because even if you haven't started that business yet, or you haven't pushed it to where you want it to be, you still file that application, and that's going to reserve your space in line, so that if anybody were to file 5 minutes after you, a month after you, a year after you, while your application is pending, and whatever the case may be, they're not going to be able to supersede your application. Okay. And with the intent to use application, you have about 3 to 4 years to actually prove that you've started using that mark in that way.
Okay. It gives you some time.
Exactly.
Okay. And I was going to ask, so is there, because you said like the United States Patent Office, so if I go through everything and do everything right here, can someone in like Canada or Mexico take my trademark? Or do I need to go through like a international process, or do I have any protection that way?
So, great question. And so the emphasis on the USPTO, because the USPTO stands for the United States Patent and Trademark Office. So that protects you, that will give you protection as it pertains to only the United States and its territories. Okay? That's the extent of your protection. If you are planning to offer your services or market your services in other countries, then you have to apply in those other countries as well. Okay? Now the catch is that you have to have a as a U.S. citizen, you have to have a U.S. registration, a trademark registration with the U.S. first, to use as a basis for your application in another country. Okay. And those applications will go through what's called the Madrid Protocol. And so you'll also see, like, in some cases, when, running trademark searches and things like that nature, you'll come across international brands that may also have registrations here in the U.S., as well, because they're also selling their products and, so on and so forth here in the U.S. So they want to make sure that there's no confusion, there's no issues with U.S. Border Patrol, so Customs and Border Patrol, so on and so forth, for potentially counterfeit goods. And so, yes, that's a really big deal for anybody that, is planning to or has a customer base in other countries. It's really important to think about those things.
Okay, yeah, because I see McDonald's is like in like every corner of the earth, so that means they got like 1,000 patents out there.
I can't like when I tell people about McDonald's trademarks, it's like it's so interesting because like just one day, just out of like just like fun and just being interested and to see like McDonald's, they have trademarks for everything. Like you think that like, everybody knows Ronald McDonald House, is their charitable, giving
Mhm.
component of the industry, right? Um,
Right.
of the brand. They've got like they have several trademarks of different variations for the Ronald McDonald House because there are certain departments up under or certain like like different little things that they do with up under the Ronald McDonald House umbrella. So all of those things are trademarked as well. Um, so that's what I meant earlier about like like it's not just the name. The name is the foundation, but like any aspect, you have to think about any aspect that needs to be protected for your brand and make sure it's on lock.
Wow.
If you look at their menu, like Mac Cafe, that's trademarked. If you look, like anything, like even if you were to go to like, I think I was it Jason's Deli or one of the like the little sandwich places, like literally almost every sandwich on that menu had been trademarked. And so like that's just like the level and again, like, that's not to add a stressor for anybody that's, at the earlier stages of their business or at their brand. Because I tell people all the time, the most important thing to make sure is protected, especially when starting out, is going to be the name, because the name is the foundation. And then you're going to naturally develop, as your, profits and things of that nature, grows over time and things like that. Then you want to look at expanding your intellectual property, your trademark portfolio, just like a real estate investor would have his real estate portfolio or his, real estate property portfolio. You would also have that same level of, organization as it pertains to your branding because you've got to circumvent everything. You've got to make sure everything is protected. And it's different for every business. It's different for every business.
Absolutely. Yeah, that makes sense. Because when you were talking, I thought about like all the names that they've customized, like McGriddle and McFlurry and all that kind of stuff like that. So that makes
Hmm.
a lot of sense
Yeah,
to, stop Burger King from having their own version or something.
exactly. And you better believe, like, and think about it, like, if a brand is gonna put at their level millions of dollars behind marketing for certain, menu items or things like that, they're gonna make sure that nobody else can run the same ad commercial. They're gonna make sure they lock down that territory, and so that's the kind of the mindset that we all have to have. If we're going to be putting marketing efforts, whether it be energy or financial resources, behind certain components that we've worked hard to, you know, create. As far as labeling, again with trademarks, if it's a label, of something that is different from what other people are calling their version of XYZ, then you might want to protect it.
Gotcha. It makes perfect sense.
Yeah.
So I want to ask, so if I have someone like that I believe is infringing on my trademark, I know you mentioned a cease and desist earlier. What, like if I call you and say, hey, Erica, look, I think this is going on, at that point, what do you do?
So immediately we do some research. Immediately. We're going to look into, because we've got to assess, what claims you could have against them. And we also want to assess what claims they could potentially have against you. Okay. And so we talked a little bit earlier about the scenario of,
Mm,
whether a company predates yours, right? And so
okay.
we want to fully assess the entire scope of everything before we just send out a letter, right? Before we just send out a letter and without realizing that, hey, this could really blow up in your face, right? And it's like,
Okay.
whoa, was not expecting that.
I should have
uh,
left you alone.
right. You poked the bear. You poked the wrong bear. And so the first thing is we definitely want to do an analysis of that particular infringer. And then we will draft a custom cease and desist letter, to be sent out directly to them or their lawyer that they may have, if they have an attorney on, on record, or, whatever the case may be, outlining all of the claims, all of the ways they're infringing on your federal trademark rights, so on and so forth. If they do not do that, then, these are the damages that they'll be responsible for, how much time they have to immediately stop using, your mark and things of that nature, and in some cases that also will end up, kind of snowballing into potential settlements. Whereas, hey, they may say, hey, can I pay, like we talked about earlier, hey, can I pay you? Can you, give me permission to use this variation of, and that may be something that you're interested in, or something that you also have the right to say no. And so we take care of it.
Okay. Awesome. And I have to ask this, because we've kind of laid the foundation stuff for trademarking. What would be, because initially we talked about equity, what would be the biggest benefactors you would say of getting a trademark versus, just kind of going the hope and pray method until I'm ready? What would be the initial benefit of having those trademarks in place?
So ultimately, it's security. It's security. It's security for you, all of your investments. And every time I say investments from this perspective of where I sit, in my profession, it's not just, your financial investment, right? Sometimes people say, oh, I only, invested, $1,000 in this business. That's not a blah, blah, blah. But how many hours did you put into it? How much time did you invest in it? So on and so forth. How much muscle did you put into it? And so it's security for all of your investment. It's security for knowing that, hey, what I'm building is not a waste of time. It's security and understanding that, whether I decide to, really push this thing or dissolve it later on down the road, I can do so with that security and knowing that this is mine. Absent having this, it is not mine. And also on the scope of looking at it from that perspective, on the contrary, it's also knowing that, hey, I'm operating something that doesn't already belong to someone else, that's building equity for someone else. Because with operating a business that does not, that we don't own the trademark for, it also daily, you're at risk of being on the other end of that cease and desist letter. Every day you're at risk for someone or another business filing a lawsuit or federal lawsuit against you, suing you for all of the money that you've made using that brand that is infringing on their rights. Okay? And not only that, but they can also potentially sue you for any money that they can, calculate damages for, that you've distracted all of their customers or potential customers. And so it gets really methodical. It gets really deep. And so it's not just about, on the one hand, we have to consider how important it is to us, but we also have to make sure that we're not, building upon something that belongs to someone else. Like we talk about those squatters. We've got to make sure that we're not, going into someone else's home. We've got to make sure we're not building on someone else's land. We've got to make sure we're not driving someone else's car. Make sure it's yours. Okay? It is doing the things to make sure that it's not only yours, but it's, making sure that it doesn't belong to someone else. That it's free territory. Okay? And so ultimately it's going to come down to how comfortable you are with, taking that risk. Because there are a lot of clients that have come to me on the other end of that, and a lot of clients who have come to me before any of that has happened. So I've seen a lot of different things, and one thing that I can definitely say with confidence is that you never know if it's going to be you. You never know, and trust me, that Instagram message, somebody sends you an Instagram message about infringing on their rights, or you getting that letter in the mail, it always comes at the wrong time. 100% of the time, it always comes at the wrong time.
I believe that. I don't want to get sued. So. And that's why I met you. So.
Exactly.
Absolutely. Yeah. Well, everyone that's listening, I do highly recommend Erica. I have used her personally for my trademark services. I'm going to let her tell you how to best reach her, contact her, and then we will close from there.
Yeah, so definitely, first of all, thank you so much for having me, David. I've really appreciated it, and I'm grateful for this space to talk about something that I really enjoy and I am passionate about sharing information about, and just working in this area of the law and working with entrepreneurs like myself who are working hard to build something that we're passionate about, and that we care about to a certain degree, right? But yes, if either of you would like to, speak with me more about your business in particular, then definitely feel free. You can visit me online at www.scotttolbertlaw.com. That's SCOTTTOLBERT law.com. You can also follow me on social media, on Instagram, at Erica, ERICA the trademark lawyer. You can attempt to find me on TikTok if it's not shut down by the time you listen to this. At the same handle, as well as Twitter. And we would definitely look forward. I would definitely look forward to connecting with you and, helping you and your business, take things to the next level and make sure that everything is protected and scalable.
Absolutely. Well, thank you for coming, Erica, and thank you all for listening. And I will see you guys in the next one.